Hello everyone. I, Forum Patel from LG School of Law would like to extend my warm welcome to every viewer in the second session of the media law on the law and the judicial part. In the previous sessions, my friends, we dealt with the media and criminal law with regard to the defamation and its 10 exceptions. In last, we did discuss about the case that was New York Times Company versus Sullivan. So friends, let's get started with the factual situations and rather certain important lines that were there in that case. So, New York Times Company versus Sullivan, which was in 1964, was considered to be a landmark decision of the US Supreme Court, in which the court ruled that the freedom of speech protection in the First Amendment to the US Constitution restrict the ability of the American public officials to sue for the defamation. Specifically, it was held that a plaintiff in a defamation lawsuit is a public official or person running for the public office. Not only must he or she be proven to the normal elements of the defamation, which is publication of false defamatory statements to a third party, but he or she must also be proven that the statement was made with actual malice, that is actual wrongful intention. The case began in 1960 when the New York Times publishes a full-page advertisement by the supporters of the Martin Luther King Jr. that they criticized the police in the Alabama for their mistreatment of the civil rights protectors. However, this ad had several factual inaccuracies such as the number of the times King had been arrested during the protest, what song the protest had sung, and whether or not the students has been expelled for participations, etc. In response, the Montgomery Police Commissioner, that was L.B. Sullivan, sued the Times in the local country for the defamations. The judge ruled the advertisement's inaccuracies, which were defamatory per se, and the jury returned to a verdict in the favor of the Sullivan and awarded him with the damages. Now, the Times appealed the verdict to the Supreme Court of the Alabama, which affirmed the same. It then appealed to the US Supreme Court, which agreed to hear the case and ordered the writ of the certiorari. In March 1964, my friends, the court issued an unanimous 9:1 ratio decisions holding that the Alabama court verdict violated the First Amendment. The decision defended the free reporting of the civil rights campaign in the southern United States. It is one of the key decisions supporting the freedom of the press in the country. Before this decision, there were nearly millions of the legal actions from the southern state outstanding against the news organizations as a part which was focused and efforted by the officials to use the defamation lawsuit as a means of preventing the critical coverage of the civil rights. The Supreme Court's decision in this case and its adoption of the actual malice standards, it reduced the financial exposure of the potential defamatory claims, and thus it frustrated the efforts of the public officials to use these claims to suppress the criticism at large. So friends, this case had a huge impact in the US Supreme Court as well as all over the world when we are talking about the defamation and its exceptions. So this led us to the next discussion of the topic about the damages. As I stated in this case that the case had given the damages as precautions, or rather as a result of the same, we have to discuss the damages and its element with regard to the defamation. So friends, compensation or rather general damages, they are designed to offset the injury which was done to the victim. If the newsman lacks the complete defense, the jury has to award the damages. There are certain elements for deciding the same. The first, as you can see on the screen, is injury to the person and the reputation. Second is the mental and physical pain and suffering. And the third one is general injury to the occupation or the business at large. In this case, that is R. Rajgopalan versus and others versus State of Tamil Nadu and others, the freedom of press, which was considered to be an article of the faith with us, sanctified by our constitution, it validated by the 4 decades of the freedom and indispensable to our future as a nation, my friends. In the present case, the proposition which is raised is concerning the freedom of press vis-a-vis the right to privacy of the citizen of this country. It is also followed it also follows the discussion as to the parameters of the right of the press to criticize and comment on the act and conduct of the public officials. The first petition is the editor, printer and publisher of a Tamil Nadu magazine, which was published in Tamil, like Madras. The second petition is the association editor of the magazine. They are seeking issuance to often appropriate writ or order or directions under Article 32 of the Constitution restraining the respondent. This whole case was about the autobiography of a criminal. The Supreme Court, while deciding this case, had taken the base as the US Supreme Court's judgment, which was that we discussed in the last session, that is New York Times versus Sullivan, which concluded that a public official can only recover the damages for libel if a publication was false and was made with reckless disregard for the truth, and also noted that the fundamental similarities between the systems of government in India, US and the UK, and found that all the demand constant vigilant cover exercise for governmental power by the press and the media amongst the other. The court next considered the judgment of the House of Lords in the UK. The House of Lords ruled that not only there was no public interest in allowing the governmental institutions to sue for libel, but it was even contrary to the public interest, because to admit such action would be place an undesirable fetter on the freedom of speech. Further, the action of the defamation or the threat of such action inevitably has an inhibiting effect on the freedom of speech. So, which is still from the crux of the concept of the freedom of press, that liberty of the press is essential to the state. No previous restraint should be placed on the publications, and does not mean that there is press freedom for doing what is prohibited by the law. Every freeman has the undoubtable right to lay what is sentiment he placed before the public. But if he publishes what is improper, mischievous or illegal, then he must be facing the consequences of his own actions. Now, there cannot be any interference with the freedom in the name of the public interest, my friends. So, the damages has to be given in any of the cases. Let it be Auto Shankar case or let it be the Sullivan case. Even the US Supreme Court and even the Indian Supreme Courts and even the UK, they are of the opinion that defamation cannot be considered, or rather the exceptions, they should not be misled, or they cannot be handed over to the person who is doing the misuse of the law only under the shelter of the freedom of press or freedom of speech and expressions, my friend. So this was all about the exceptions to the defamation, the concept of the defamation, section 499, and the damages which are arising out of this defamation. We shall be talking about the next session. In the next session, the topic of the sedition, which also is considered to be a crime under the media segment. So friends, till then, keep learning and stay tuned.